before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at Sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here.
We're back up in Massachusetts with Karen Reed. She's accused of killing her boyfriend with her car. The first motion the judge is deciding is whether Karen Reed's legal counsel violated any type of rules relating to the disclosure of compensation to an expert witness. Let's see what happens.
So we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of
And for some reason in Massachusetts, they don't pronounce the R's.
ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts.
There's a judge there. They call her Aunt Bev. She should be accused of violating the first rule of fashion, never cut your bangs, which she obviously does.
I've listened to the Sidebar conference and read that transcript, and I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses.
The ARCA witnesses were witnesses that were presented to be independent, meaning neither side was paying them. It turns out there was some slight compensation made by Karen Reed's counsel, which should have been disclosed. And in subsequent representations to the court, both oral and in writing, the compensation was never disclosed. And that's what this judge is deciding on now.
They were made at Sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. On February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control.
That means that if you're claiming it's an independent expert witness, you don't have discovery relating to how much you paid them, what their reports are going to be. It's technically outside of Karen Reed's control. If there was communication, if there was compensation, then that would have to be disclosed and produced to the Commonwealth.
The defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that was a
The ARCA witnesses were originally hired by the federal government during their investigation of any type of wrongdoing on behalf of the police there. Obviously, if you're representing Karen Reed, it's amazing to have experts that side with you for which you're not paying. And apparently, that's not what's happening here because there was some compensation after they found their initial findings for the federal government.
Material misrepresentation, and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations, and before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at Sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So,
as an attorney, that's never a great feeling, but let's see what happens.
So.
I've made this long walk before. They're going to seal this sidebar, but what's going to happen is the judge is going to say that your attorneys violated this specific rule. Do you want to continue with them representing you knowing that they broke these rules? The Constitution grants you the right to have counsel of your choosing, even if it's ones that apparently break the rules. Karen Reed is going to confirm to the judge she wants them all to remain as her counsel. Basically, nothing will come of this because she's going to confirm that. Now, the judge did say that she's going to first speak with Karen before determining what type of sanction there could be. Other potential sanctions could be monetary sanctions or a censure, which would mean a public disclosure about the attorney. Probably won't see that here. They probably won't exclude the experts, and we'll see what actually occurs after this sidebar. That is the most famous fan in LawTube history. Make your walk of shame back to your table. Act as if nothing happened. You got to act cool if you're the attorneys. You fake talk about different things. You just want to act as if nothing occurred.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Yeah, I never understood what was going on with Jackson's face. It looks like he must have some form of a scar there, and that's why he does this partial beard. I'm going to look into that.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But
So Yannetti is the only licensed Massachusetts attorney on the team. You can represent someone in a foreign state for which you're not licensed, meaning that if I'm licensed here in New York, I can represent someone in Massachusetts if the court allows me. And that's where the term pro hoc vice comes in. And everyone else on this legal team is being admitted pro hoc vice just for this one particular case. Generally, you need to have someone that's licensed in that state in order to be admitted pro hoc vice on that legal team.
Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses.
That was a potential sanction, revoking their pro hoc vice license, meaning that none of the attorneys besides Yannetti could actually try this case.
I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as
She has to let those bangs grow out.
good as his or her word, and I need to be able to take counsel at their word. So, I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your
So now the lawyers can't stretch the truth a little bit?
closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as...
And that's what the Commonwealth wanted, because those witnesses, despite being slightly compensated by Karen Reed's legal team, are very detrimental to the Commonwealth's claim.
In Massachusetts, a lawyer is only as good as his or her word.
Uh-oh.
And I need to be able to take counsel at their word. So, I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to to exclude the ACA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on.
In the end, that's good news for Karen Reed. The ACA witnesses will be allowed to testify. They have to disclose any type of compensation, which is fine, and they will get cross-examined, which is fine. That's exactly what Karen Reed wanted. This was a great outcome for Karen Reed. The judge made the finding that the misrepresentations, technically the omissions by her team, not disclosing that she actually had some form of compensation to the ACA witnesses, was intentional. That's a big deal. Now, if it's unintentional, it's a different situation, but here the judge determined that it was intentional, that they intentionally didn't disclose any type of financial compensation to the ACA witnesses. She could have excluded them completely, but she's not going to. So in the end, this is just fine for Karen Reed.